Hello and welcome to Calm the Pharm podcast, where pharmacy business meets legal wisdom, minus the headache. In each episode, we share practical legal tips and real-life examples to help you run your pharmacy with confidence. I'm your host, Sarah Stoddart. Thanks very much for joining us. Today on the podcast, we're talking subleasing. Now, regardless of where you are located in Australia and the business that you operate, it is highly likely that you are operating or occupying your premise pursuant to a lease. In most cases, the premises you are occupying is owned by a third-party landlord. However, there's also circumstances in which business owners may own their own premises via a different structure to their business, and a common one is, of course, a self-managed superannuation fund. I'm not here to talk about superannuation funds, however, I am here to talk about subleasing and the importance of making sure you can actually lawfully sublease, irrespective of whether you own or occupy the premises. Let's assume for the purposes of this discussion that you have a lease in place. It doesn't really matter whether your landlord is a third party or whether it's yourself via a different structure. But your lease will contain a provision which says you are or are not able to sublease. Quite common in leasing is for the provision to say that the tenant is not required to sublease without the landlord's prior consent. So this means that the starting point is that the tenant, the business owner, is not permitted to sublease the premises to a third party, but they can ask the landlord for consent to sublease. Now, if we take a step back, what subleasing actually means is that you part with part of your premises or the whole of your premises to a third party. So if you have a pharmacy premises and you want to sublease some of that or part with some of that area to a third party, for example, it's common in pharmacy to see subleasing to allied health professionals or beauty services, injectables, that sort of thing. So if you want to do that and part with part of the area that you occupy, you need the landlord's consent to do it. Now, landlord, when consenting to a sublease, will look at a few different documents. First of all, they'll want to see the proposed sublease, so they'll want to know on what terms you're proposing to sublease to the other party. They'll also want to know information about the other party, and that information includes, of course, who it is, their business experience, and possibly also their financial position. So it's important to be aware that that information will be requested and to take steps to get that documentation prepared before the landlord is approached to consent to the sublease. In terms of the actual sublease document itself, I would recommend not having it signed until the landlord has actually consented. Otherwise, you run a risk of going to the process of having it signed only to then have to make amendments to it and have it re-signed. So in a nutshell, that's the consent process. So the starting point, if you are looking to sublease, is to check your existing lease and see what it says about subleasing. The next step is to prepare your sublease documents and have them ready so that when you approach the landlord to give consent, you can hand those over. And of course, the third step in that nutshell description is to approach the landlord for consent. Doing so after having reference to your lease to see what is required. Landlords have differing views on subleases. Some love them, some hate them, some are a little bit indifferent. However, when you're preparing your sublease document and negotiating the terms of that with the proposed sublessee, there's a few things to keep in mind. Firstly, the use of the sublease space needs to be consistent with the use of the premises referred to in the lease. So if your lease is just for pharmacy and you then want to sublease for the purposes of, let's just say, office, then that's not consistent because an office isn't typically part of a pharmacy use. Of course, pharmacies have offices in them, but it's not referred to as an office style of business. So when you are thinking about subleasing, you've got to make sure the use is consistent. You need to have some foresight and long-term thinking when you're entering into your actual lease to ensure that the permitted use of your lease is broad enough so that it captures the uses for which you may want to sublease. For example, if you want to sublease to an allied health professional, perhaps there's a pediatric specialist or a physio or a masseuse or someone that wants to use part of your premises for 3 or 4 days a week, then what you could do is when you are negotiating your lease, you could make the use, for example, retail pharmacy and other allied health professional services. That then would capture the permitted use under the sublease. Just because your use in the lease is broad, in that it refers to the allied health, does not mean you then have to do that use. It just allows you to do it. It is the permitted use should you wish to use the premises for that purpose. So that's one thing we see quite often, is that the proposed sublease use is inconsistent with the actual lease use, and there needs to be consistency. So make sure you check that, and make sure if the use you want to put into the sublease arrangement is inconsistent, the landlord will need to consent to the change, and potentially your lease will need to be changed before that can be allowed. Also relevant to the use consideration is whether or not the planning scheme and the other legislation which governs the land on which the premises is located, whether that in fact permits the use that you want. So that's an important consideration. Another important consideration when negotiating subleases is whether or not the terms are consistent with the head lease. So when you have a lease, that becomes the head lease, and typically subleases mirror the terms of the head lease. So that essentially means that the sublessee steps into the space they are occupying on the same terms under which you occupy your lease. So the terms are mirrored. In some instances, people want to change the terms of the sublease, and that does get confusing because it means your sublease document needs to be drafted in a particular way and with reference to the head lease. You need to ensure that they match up. If they don't match up, we then have an inconsistency issue, and you need to ensure there is a clause in the sublease which deals with that. That is, which deals with which document, being the sublease or the head lease, will prevail if there is an inconsistency. So when you are looking to sublease your premises, it's not just a matter of finding that third party you want to give a sublease to and saying, yep, no problems, you can move in on Monday. It's about actually taking a commercial approach to it, making sure you have the right documentation in place before you enter into the sublease, and then ensuring that the sublease is drafted appropriately. That will also make your process of obtaining consent much easier. The other thing that's important to consider with a sublease, and many people don't know this, is that a sublease term must finish at least the day before the end of the head lease. So that means that if your lease expires on, let's just say, the 30th of November, your sublease can't expire the same day. It has to expire 29 November or earlier. This is another mistake that we see quite often, is that the sublease document just has the same expiry date as the head lease. That can't happen. You need to make sure it finishes at least the day before. The other thing to keep in mind is that if your sublease has option periods and your head lease has option periods, the sublease options, or the term of the sublease, if there is no options and rather it just continues for a term, that must be subject to the options in the lease being exercised. Otherwise, you have a potential situation where your sublease term extends beyond the terms of the lease, and that can't happen because it's a sublease which is reliant on the lease being in place. So you need to make sure two things there. One, that your sublease expires at least the day before the expiry of the head lease, and two, that any options are made subject to the options in the lease being exercised, because you can't exercise an option under a sublease if the lease isn't in place. That's quite a technical episode today, but that highlights some of the key issues we see with subleasing arrangements, and hopefully you found that useful. Finally, before we wrap up today's episode, I just wanted to thank our listeners who have listened to this podcast. I love getting feedback from listeners. The purpose of this little note at the end of this episode is to let you know that our last episode for the year is going to be on the 8th of December. After that, we'll be taking a break and we'll return fresh and new in 2026. Thanks very much for listening. I look forward to speaking with you soon.